Hello again, everyone. My name is Tom Reilly. I'm the chairman of the Business Services Group at Gross McGinley. With me is Jesse Kaczinski, one of our business associates. And Jesse's been working closely with me since earlier this year on the Federal Trade Commission, the FTC's efforts to ban non-competition agreements nationwide. That ban was supposed to take effect on September 4th. Spoiler alert, this is maybe one of the only times in your life where you're going to seek out legal advice on a vlog and find out that the answer at the end is you need to do nothing. Great news. We're going to tell you how we got there. So first of all, Jesse, why don't you tell us a little bit about what the FTC tried to do and what would have happened with regard to non-competition agreements on September 4th had it been successful?
The FTC had issued a rule which would have required that non-competes, existing covenants with employers and employees no longer are enforceable come September 4th of 2024, which would have meant that employers would have had to notify all employees before September 4th that existing non-competes were now non-enforceable and to no longer enforce them against employees.
Now, there's more nuances to that. There were things that were not rendered unenforceable. We won't get into that now because something very important happened this past week. There have been several legal challenges to the FTC's ability to, in fact, regulate non-competition covenants. It was something that had never been done on the federal level before. It had always been done at the state level. And there's various cases that had been working their way through the justice system. Why don't you give a highlight, Jesse, on what happened with the Ryan case in Texas and the result of that opinion?
So August 20th, the Ryan court decided, Judge Brown of the Northern District of Texas, that the FTC ban on non-competes was non-enforceable. The judge had issued a ruling that the ban was arbitrary and capricious and was overly broad. Specifically, it was wider than any states had previously enforced, and it didn't target just specifically harmful non-competes, but all non-competes.
So as of now, the FTC rule that was going to become effective on September 4th, the ban on non-competes that was going to become effective on September 4th is not happening?
Correct. So as of September 4th, nothing is happening right now.
So what happens next with the Ryan case, if anything?
There is a potential for appeal. The FTC could appeal it to the Fifth Circuit and potentially all the way up to the Supreme Court. However, the likelihood of that happening is a little iffy right now.
And even if the FTC does appeal, I'm assuming that would take years before it's resolved?
Yep, we would have a decent amount of time before it's resolved, potentially years, and the rule would still be non-enforceable during that appeal period.
So as I said at the start of our little meeting here, you need to do nothing. That was far different than what we've been telling many of our business clients all summer long about getting ready to get these notices out the day after Labor Day to be compliant with the law. Right now, the FTC ban on non-competition agreements is no longer enforceable by the FTC. Nothing has changed from the enforceability of non-competition agreements as they exist today. It'll be the same on September 4th and thereafter. Thanks for taking a couple minutes to join us. Once again, thank you, Jesse, for your hard work on this topic and for participating in our little meeting today. And thank you for joining us. My name's Tom Reilly.